And I'm sure they didn't do that just by accident. They no doubt did that because they thought you were responsible enough to manage their operations, to manage whomever you have to manage. People are not always easy, especially in that jungle. There are so many different kinds of animals, I'm sure, and there are animals everywhere. That's unique to yeah, she'll tell you. They're everywhere you go. You don't get over it. So that's a great thing. And then having a little girl already, that means that will change your perspective almost overnight. Children will do that. Okay? I'm almost ready for death, and I have a son who's 21 because he was born very late in my life compared to my peers. So I'm still stuck with him for another 2 years of college and all that crap. So yeah, children, at least you're not gonna have that problem. Okay, you're gonna be finding around early, which is the benefit of having children younger. Um, so that's good stuff. That's fantastic. So welcome aboard. And, okay, so let's just jump right into this. I only have two readers so far today, but that's okay. Even the Bible says where there's two, we'll doggone make it seem like 20,000. So we're gonna do that. Like I was saying, Sabrina, just go ahead and start reading from the beginning of the unit. If you haven't done so, wherever you are, just continue reading straight to the end. We're going to continue on. Santina, do you remember where we stopped the last time? You were. Oh, that's right. You had to leave early. Okay. Say it again. That's okay. Yes. But we hadn't finished Unit 1. So we're going to finish the rest of Unit 1. We stopped on page 16 under Transfer of Trusts. Just before we got to that, we were on page 15, talking about the general types of trusts. Does everybody see that? Your 15 might be a little different, like a page different. It says general types of trusts, express trusts. Okay. We kind of talked about that a little bit, then we went on to trust transfer. So let's back up the general types just for the two of you. Um, Basically, we have 5 types of trusts out there. Okay? The first one is what we call a non-discretionary or fixed interest trust. This kind of trust allows the trustee to make no decisions on their own. Okay? Once the trust document is prepared, the trustee has to follow the instructions to the T. That's what we mean by non-discretionary. Okay? Discretionary, on the other hand, means the trust agreement allows the trustee to make decisions based on their best judgment. So, for example, in a non-discretionary trust, notice the example that is given. It's very specific. It said, I give 20,000 to my trustees to divide equally between my children, John and Mary. There's no doubt about what the trustee has to do. The trustee cannot change that in any way. That's what we mean by non-discretionary or fixed. The settlor has said what he wants, and that's it. Now, just for the sake of Sabrina, since she's just joining us, Sabrina, whenever a trust, and you'll see this when you get into the reading, and if you have any questions, you can raise them. Whenever we establish a trust, basically what a trust does is this: the person who owns the assets of a trust, we call that person what, Santina? She was here. Do you remember? The S word. The settlor. Okay? The settlor is the person who owns the assets, whatever they might be. Okay? Now, if you own a car, Sabrina, then you have an asset. If you have $10 in the bank, you have an asset. You follow what I mean? If you own a pair of shoes, you have an asset. Hi, come right in. Good morning. The rain tried to rain you out. I know. Yes, I know. We can be. Okay. Here we go. we have a new kid on the block. Sabrina, Rico. Yeah, we're just kind of getting started. Trying to bring her up to date a little bit before we go on. All right. So the settlor in a trust is the person who actually owns the assets. Now, you may have heard about a will in your lifetime. When I die, I want to leave everything to my daughter. See, not her stinky husband. To her. We don't leave anything to husbands. Since we're talking about trust and wills. Some people do? Okay. Stop it. I must be. I missed the boat then. Yeah, every now and then we even leave it to a boyfriend. That's rare. Yeah, it's a rare moment in time because most spouses, husbands would leave either to their wife or their mom. One or the other, the wife first, the mom, or both together, something like that. But often, most times, wives don't leave it to their husbands. They leave it to their children or their mom or their dad or even their sister. Like my sister, not their husband. Like whatever, if you starve to death, that's your business. I don't know why that happens. Because really, it should be both ways. If he's prepared to leave his wealth to you, you should be prepared to leave your wealth to him. Unfortunately, because of any number of reasons, people don't do that. It just doesn't happen equally for whatever reason, unfortunately. But this is what the trust is all about. The trust is like a will, where somebody who owns assets says to a trustee, I'm leaving my assets with you so that you can look after my children and their children, especially if you have lots and lots of money. But you don't have to have lots of money and wealth to have a trust. Okay? Even if you have $100,000, you can say, I'm leaving it with a trustee so that when I die, that the trustee will distribute the money and manage the money the way I would like it to be managed, similar to a will. Okay? So when we set up a trust, we leave instructions with the trustee. The trustee is the person who manages the trust. Person or institution, remember? The trustee can be a person or an individual or an institution. As you'll see, as you've seen. Okay? So if you have a small amount of assets, you want to leave it with somebody you trust, that would be a personal trustee. If you have a whole bunch of money or an underlying company, a whole bunch of wealth, you don't want to leave that with a person necessarily, even though you could. But you may not want to do that. You may want to seek out a what? Institution, what we call a professional trustee, who will then be looking after your assets, hopefully with great care, and who will carry out your instructions according to your wishes. Okay? So that's the settlor and the trustee, and the third party to the trust agreement, to the trust function, is the, who's that? Beneficiary. And of course, the beneficiary is the person who actually receives the benefit of the trust. Okay? So the settlor, the owner of the asset, says, every year, I want you to give $25,000 to each of my children. Those children will then become the beneficiaries. But the beneficiaries do not have to be your children only. They can be anyone or any institution you want it to be. Okay? So if you have a favorite dog and you hate your children, you can leave it to your dog, which many people do, by the way. Okay? All right, so that's just a little, and of course the agreement, Sabrina, that controls the whole trust is what we call the, anybody remembers? What's the controlling instrument for the trust? The deed. Yeah, the trust deed or agreement. And this is just a written document that it outlines exactly what the settlor or the owner of the assets desire. There's another document in the trust world called the Letter of Wishes. This document does not have any legal basis like the instrument, but it does sit behind the scenes. And what happens in the Letter of Wishes is this outlines the settlor's personal desires in terms of what they would really like the trustee to do on their behalf. Make sure that my child who is blind never suffers a day. Make sure that child gets a little bit more than the other child who is not blind. Whatever your desires are, you put it in the letter of wishes, and that will sit on the file for the trustee to consider when he or she is making decisions about how to distribute the assets of the trust. So that's a little background. Again, a little reminder for some, a little introduction for others, because this is really the foundation of everything else we're going to do along the way. Okay? It's all going to hover around the trust instrument of the trust deed, the settlor and his or her wishes, the trustee and the trustee's fiduciary responsibility. Keep that word in mind, fiduciary, because that's going to come up quite a bit. Fiduciary. Fiduciary means that the trustee has to act in good faith. In other words, if you left assets in trust for beneficiaries, you cannot use the money for your own personal use. You have to use it for the purposes outlined in the trust. And so fiduciary means you have a duty of care. That's what it means. Just put that here. Fiduciary duty of care. In other words, if you're a trustee, personal or institutional, you have a responsibility to make sure that you handle the wealth that is left in your care with care. Okay? That's what fiduciary is all about. It's not a difficult concept. It's just for some institutions and people, additional concept to execute, depending on a person's agenda. All right, so the non-discretionary, so that's the background. Going back to general types again, the non-discretionary or fixed trust is very specific. The settlor leaves very specific information with the trustee. The trustee has no discretion in how to do it. They have to do it exactly the way the settlor says. If they do not do it, they may find themselves in breach of trust. And what does breach mean? You didn't do what the settlor said in writing. Okay? Most, if not all, trust deeds and agreements are in writing. That's why we call them expressed. Okay? You should try not to deal with a trust relationship that's not in writing. So you find yourself in trouble sooner rather than later. All right, the discretionary trust, on the other hand, does give the trustee some leverage. The trustee gets to make a decision based on their own personal judgment and experience. They don't have to listen to what the settlor has requested. They are free to go ahead and make some decisions of their own that they think are prudent and in the best interest of the beneficiaries. Okay? So on the one hand, you have a trust that is fixed, exactly the way the settlor wants it. On the other hand, discretionary, the trustee gets to use his or her discretion in making that decision. Then we have part discretionary, part fixed, which means that a trust deed might have a combination of both. That happens occasionally, depending on the situation. For example, if a settlor has a child who is disabled, and then maybe a child or children who are not, it might be part fixed, and the fixed part might say, make sure that the disabled child gets 20% more than everybody else every year, because they are disabled. And then the other part of the agreement might be, and for John and Mary, you can use your discretion. Okay? So in a case like that, it'll be part discretionary, part fixed. And then of course we have the revocable trust. Anybody remembers what that one was? Some people call it revocable. But this is a trust instrument where you can set up the trust, and the settlor has the ability to recall the trust or cancel it sometime in the future. Okay? So we refer to that kind of trust as a revocable trust. You can revoke it or take it back so that it doesn't exist anymore. You find some cases of that. Then you have the irrevocable trust, where once you set it up, you can't do anything with it. That's it. It's there forever until something happens to close the trust down permanently. And we'll see how that happens later on. Once the trust is set up, it doesn't mean it cannot be terminated, but if it's irrevocable, the settlor cannot come back a year or 2 or 3 or 5 years later and say, I don't want this trust anymore. He can do that, only do that on a revocable trust. Okay? So those are your key types of trusts. There are many other types, but these are the key ones that you'll see in terms of express trusts. And again, remember, express means written, for sure. All right, so let's look at the transfer side of trusts. See how that works. In other words, if you set up a trust in the Bahamas, does it have to stay here or can it go somewhere else? And we'll see in a moment that the trust doesn't have to stay. It can indeed be sent somewhere else. Okay. So since Rico came in last, we'll pick on Rico first. The last will be first. Okay, that's sick. Okay, Rico, let it rip.
An important feature of modern trust law is the principle that the transfer of a trust from the original trustee resident in one jurisdiction of new trustees resident in another jurisdiction must be made in accordance with the provision of the trustee and in compliance with the trust laws of the jurisdiction that govern the trustee in order to be properly effectuated.
In other words, if you want to make a transfer, it has to be in the deed that you can do that, and also it has to be possible to do it in the jurisdiction that you're trying to send it to. In other words, if you want to send it to another jurisdiction and they do not have a similar laws or they don't want to receive it, then you can't send it there. Okay? It has to be, those two conditions must be met before you can transfer.
So you have to state in the trustee that it's transferable.
That is transferable, yes. Because some trustees might indicate that it's not, or they don't wish it to be under any circumstances. And others, as a standard clause, might say in a trust deed, this trust deed is transferable. And you'll see why folks would want it to be transferable and what the conditions are very shortly. Okay? So this trust instrument is kind of like when you set it up, you try to cover all the possibilities if you can. Sometimes we miss stuff, and that's how things end up in court. But for the most part, when we set up the trust deed, and lawyers, by the way, normally would do this. Okay? Trustees themselves don't get into writing up a trust deed. That is a legal document. So 99.9999% of the time, that trust deed is prepared by an attorney somewhere. Because they are supposed to be.
Sorry for my lateness.
Okay. Grab a chair. They are supposed to. You were in our last session? Okay. Okay, just fill this out for me, please. The attorneys are supposed to have the experience and the skill, especially attorneys who deal specifically with trust, because there are some attorneys firms that they have persons who deal specifically with trust, just like you have persons who deal with matrimony and criminal law and all this kind of commercial law and so on. You have attorneys who are pretty skilled in this particular area, and they're the ones who would normally do this thing. Okay, keep going.
The proper law of a trust is the law that is specified under the terms of the trust deed. If the trust deed is silent on the proper law which governs the trust, the proper law that will be applied to the trust will often be that with which the trust is most closely connected. Consideration will be given to such factors as the place where the actual administration of the trust is carried out, the place where the assets of the trust are situated, the place of residence of the trustees, and the place of residence of the beneficiaries.
Okay, so in other words, this thing about proper law, it sounds very sophisticated, and it is, but really, all it is suggesting is if the trust is being set up in the Bahamas, for example, then the trust deed should indicate that the Bahamas will be the proper law jurisdiction. In other words, any action taken against this trust or by this trust should be heard in the Bahamas. Now, if the deed does not indicate the jurisdiction, or if you're not sure how to select the jurisdiction, these are the kinds of things that we will consider as a trustee in terms of coming up with the proper law for a particular trust. And one of those things happens to be wherever the trust is established. That's a good place to consider having the what? Proper law. Okay. So if your trust is established in Timbuktu, you may have the Bahamas as the proper law jurisdiction where legal proceedings can be heard with regards to that trust, but not necessarily. It might be in Timbuktu if you want it, but you might want to have a trust in Timbuktu, but you don't want your legal affairs to be handled in Timbuktu pertaining to that trust. So you will designate the Bahamas or some other jurisdiction as the proper law jurisdiction for your trust. Again, all of this is done in advance. You don't do this stuff when something happens. You try to determine in advance how you want these things set up, so you can put it in this almighty document called the trust deed or trust agreement. They're the same. Okay, keep going.
Although settler may choose to have a trust administered by trustees in a jurisdiction different from that of the proper law of the trust, it is advisable that he chooses the proper law of the trust based on where the trustees are resident.
Yes.
Since the courts of the proper law jurisdiction would be more inclined to afford protection to local trustees should a dispute arise in relation to the
No
trust.
question. Wherever the trustee is, that's always the best place to have the proper law. That's always the best place to have the case heard. Absolutely. Other than that, I'm not saying it can't work anywhere else, but it's more dubious and doubtful that you'll get the outcome that you desire. Okay.
Additionally, a settler can avoid obvious management, control, and taxation problems by appointing trustees who are resident in the proper law jurisdiction.
Absolutely.
In most trust deeds, there will usually be some provision that cover the power to change the proper law of the trust to that of another jurisdiction. This power will often be given to the trustees of the trust, and a deed of declaration is executed by the trustees to effectuate the change of the proper law.
Okay, so if we decide to change the jurisdiction, we can do that, not a problem. The trustee will prepare deed declarations that we hereby declare that we want to transfer the proper law to, from, and so on. Should the trustee do that personally? No. When the decision is made to change or transfer, we go back to the lawyers if it's not in the original trust deed, and they will draw up the agreement. Trustees are not lawyers. A trustee might be a lawyer, as a personal trustee, for example. Let's say one of you have a life insurance policy for $100,000 and you want to leave it for your child or children when you die. You won't go to a professional trustee. It's too expensive to go to an institution like whomever, trust company. You'd probably want to go to somebody you trust, which might be the family's what? Attorney, whom you hope you can. Can you trust every attorney? No. How about your pastor? Can you trust every pastor? No. You feel like you should be able to trust them, and you should, and sooner or later you would have to find somebody to trust. Okay? But I'm just saying, those kinds of persons would be what we call personal trustees. But usually, in an institutional arrangement for a trustee, all the legal work is done by a law firm, okay, for obvious reasons. Okay, keep going.
However, it should be noted that reference should also be made in the trust deed of the desire to change the law for courts chosen to adjudicate any future disputes or problems relating to the trust as well.
Okay, and notice the point, it should be noted that reference should be made so that in the event that you don't wait until there's a disaster or a desire to decide, oh God, let's do something. It might be too late, depending on what's going on. And you'll see what I mean very shortly. All right, so this is a provision that we want to make somewhere in the trust deed, that this deed is transferable in the event of whatever the case might be. Okay. All right, keep going.
The most common method of transferring a trust to another jurisdiction is by having the existing trustee appoint new trustees in the chosen jurisdiction and then retire from the trust.
Now that's interesting. So if you're a current trustee and the trust is going to be transferred to another jurisdiction, the existing trustee will then make provisions to transfer the trust, and then the current trustee will what? Retire from the trust. Meaning they will no longer be responsible. There will now be a new trustee in the new jurisdiction. Okay? So in other words, you won't be trying to manage the trust from here in another jurisdiction. The trustee should be in that jurisdiction, obviously. Okay. That's like trying to manage a trust from here that's in another jurisdiction is like a long-term relationship. Anybody ever been in a long-term relationship? Like I'm here and think I'm somewhere. They hardly work. Yeah, they hardly work. Same thing with a trust, it wouldn't work. Okay.
In a trust deed of retirement or appointment. On the retirement of the
Now, sorry, Rika, let me just make a point there so you don't miss it. That reference to trust deed of retirement, notice what the next word is. No? A-N-D is a word. I know, it seems so subtle. Let me tell you a little secret about subtleties that maybe like that doesn't come to you guys yet because you haven't been confronted. You see this word A? Believe it or not, that is a word. See this word? A-N-D. That is also a word. Sometimes in law, one single word can make you or break you, depending on who the lawyer is dealing with the matter. A keen lawyer will read something and they'll pick up on one word and say something like, and mind you, winning the case until they find that one word. Excuse me, Your Honor. I beg to show the court that because we have and instead of a, whatever the intention may have been, this changes the whole context of the case. And all of a sudden, you have a nightmare on your hands because of that one word. Now, why do I say that? If we go back and look at that little expression, if we were to say deed of retirement or appointment, that's different in law from deed of retirement. Absolutely. In the first case, it's like you have an option, but the real intent is you don't. The process is first you establish a deed of retirement, the lawyers will write it up, and then what do you do next? You establish a deed of appointment. So the current trustee does what? Retires by preparing this deed and signing off, and then who picks up the deed of appointment? The new trustee. Okay? Which the old trustee may sign just to say, yes, I'm retiring, and yes, I am aware that's the new trustee. So these two documents are two completely different documents that have two what? Different functions. And they apply to two different trustees. Very important when it comes to transferring a trust. Some entities, trustees, for example, because they're not aware of it or because of their haste to transfer the trust and all this stuff, they may just transfer a particular trust without doing the what? Deed of retirement. And all of a sudden later on there's a conflict, there's a case, and then suddenly somebody says, excuse me, can I say the deed of retirement? And all of a sudden everybody rushed to the file, remember the almighty file, trust file, and everybody's looking at the flick. Where is the deed of retirement? Come to find out, it was never done for any number of reasons. And remember, trusts are what we call legacies. Anybody ever heard that word, legacy? A legacy is a what? Like a will, like a long-term thing that's left to you. So a trustee could be in existence for what? Potentially hundreds of years. Potentially. So a trust. So if you have a trust that's 30 years old and suddenly the transfer issue comes up and you can't find the trust deed of retirement, then that means you have to go way back to see what happened to that document. God himself only knows sometimes. Okay? Say it again. The deed of retirement? Well, then the existing trustee could be charged with stuff that they don't want to be charged with. Because as far as they're concerned, the trust was sent a long time to the new trustee. And then some crap comes up, and then the beneficiary say, but you're still the current trustee. And they said, no, I am. We sent it over there. And they said, really? Prove it. We need a copy of the what? deed of retirement to show that you retired from this? Absolutely. And if you can't find it, Santana, then you have a problem as a trustee. See what I mean? Absolutely. So the trust relationships are not always hunky dory. It may look so when you drive past a trust company. Man, that's cool. I want to work there. What you don't know is that they're not all heaven and earth. Like everything doesn't always go smoothly. Crap happens all the time, depending on who and what is going on with those relationships. Okay? And this gang, you'll discover later on, is a strange group. These people called beneficiaries. Because once they find out, for example, that they're beneficiaries, then all of a sudden you as trustee have all kinds of things going on. Okay? Rico has an idea because she's beginning to see some crap from trustee and yeah, in the real world, which some of you don't have that experience yet. Eventually, some of you will get it, and when you get there, you'll see, like Rico, that this is really the nice, sweet academic part, which is important. You have to know this, okay? Because this is like the foundation. But once you get into the war, it's like going to boot camp and training to be a soldier. And then when you hit the battlefield, like, what the flick? You discover you're just trying to save your life. Oh, Jesus, help me, start saying prayers, all kind of stuff you don't say in boot camp. It's kind of like that. All right? And sometimes all that training, it's like that sometimes. All right? So, good luck for those of you who are not there yet. Don't let that stop you, though. That's what makes it exciting. Quote unquote. Okay, keep going. Keep going.
On the retirement of the existing trustees and the appointment of the new trustees, the assets of the trust will be transferred to the new trustees or will automatically vest in them.
Okay, so once you're transferring the trust, not only do you have to retire from it as a current trustee, the current trustee also has to remember to send the assets. And if you don't remember, that's okay, the new trustee will remind you. Excuse me, John Doe Company. I see your deed of retirement, I don't see the assets yet. Okay? You need to send them. Because sometimes when it's time to transfer assets, trust companies tend to move slowly for any number of reasons. Because some assets are not even easy to transfer. If it's cash, you just send a check, maybe wire transfer, and everybody is happy. Yay, 50 million came in, wired yesterday, and so they have a party. But what happens if the assets are not cash only? Suppose one of the assets is 2 yachts. That means all kind of title deeds have to be transferred from the current trustee to the new trustee, based on the yachting world, see? And that's a whole different issue. You may even have to find a yacht attorney even, because your attorney may not have the experience to deal with what? A transfer of a yacht. Suppose you have a Leonardo da Vinci painting. Where is that being secured? Oh, that's in Morocco under lock and key. Oh, now you have to start talking to the people in Morocco so that you can make provision. You may not be moving it from Morocco. The new trustee may not want to move it. It's safe. Leave it there. But we all need to fly there, verify it, get a professional to say that's the correct one. That's not a flicking fake. All kinds of things. So when we talk about transferring assets in the classroom, we're like, oh, what an academic exercise. We get it. But in the real world, okay, it's like having a baby. If you never had a baby, people tell you, what kind of stupid is about a baby? Oh, yes, when your parents go in the living room screaming, there's the baby. But in the real world, it's never that simple. Nobody ever talks about morning sickness, how miserable you are, your moods, the fact that you could lose your baby, abortage, or the child could die before. Nobody has that conversation. We just have the what? Honky-dory transfer the trust. So even the person who's receiving the trust, the new trustee, they have to be thinking, what? Do I want this trust? Because when they look at the assets, I don't know about that. A yacht? The Da Vinci painting, I mean, have to be responsible for that kind of asset, making sure it's properly secured and insured and all that crap? I don't think so. They might decline it.
But for things of that high value, I assume they would do an actual institution instead of letting someone up, instead of someone doing a personal, like personal.
Yeah, you
trust.
won't see that with a personal trustee.
Right.
I'm not saying it's an impossibility, but you will not. 99.999, but nothing percent. You won't see that kind of arrangement with a personal trustee. That kind of transfer will always occur in an institutional trustee environment. Okay? Anybody here other than Rico is familiar with what a trust company is? Ever heard about a trust company in your life? The name of a trust company? Which one?
And City Trust and
Okay, City Trust, yes.
Credit Suisse have one.
Credit Suisse Trust, okay. Okay.
Scotia.
Yeah, Scotia Trust. Absolutely. And she's familiar with the big guns. The only big gun she hasn't mentioned is UBS Trust. But yeah. So these are all major trust institutions. Now, they're the big guys, but there are a lot of small trust companies around doing trust work, having a ball as trustees. Okay? They may not be in the mega millions, billions, but they're certainly down there with their millions making money and doing trust work. And it's okay for you guys who may not be familiar with the trust world at this stage. As time passes, you'll become more and more familiar. In fact, you should be more familiar now than you were week before last. It's a slow process. You learn it, you get it, and it takes time to get there. All right. Trust me, even people who are working in the trust environment are still learning about the intricacies of trusts. People who've been in trust for years are still fighting with trust issues. Is it black or is it white? We always did it this way. When there was a hog dog bank, we did it that way. But we don't do it that way here. See what I mean? How come? I know. And it goes on. So this is not an overnight affair. Being a trustee is like being married. I guess that's the husband, wife. Yeah, I mean like being married. Okay, keep going.
However, this method is only effective if the new trustees are resident in a jurisdiction that has trust laws similar to or based closely on English law and the trust laws of the jurisdiction from which the trust will be transferred.
Okay, folks, so English law is where all the trust stuff started back, way back when, hundreds and hundreds of years ago. Okay? That's where trust law, trusteeships began, and that's where trust law evolved from, under English law. Many countries of the world do not even believe in the concept of trusts, as you'll see later on. But in the English law version of it, like us, other Commonwealth countries, those of us who follow English law, then trusteeships are well known and not feared. If you don't, those countries are like Russia, Eastern countries, let me put it that way, who are not into the issue of English law and trusteeships, they are not comfortable with trusts. And the big problem they have with trust is transferring their assets, see, over to another institution called a trustee. Because once you transfer the assets, your millions, billions, trillions, you don't own them anymore. Make sure you understand that concept clearly in the business of trusts. Once the settler or the owner of the assets transfers them over to the trustee, you do not own them anymore. You cannot go and get them back unless you make provisions in the trustee to get them back. And most times that is not the case. Very important point. And so certain jurisdictions in the world, they don't believe in that transferring of their assets, and therefore they are not happy with the concept of trusts. But those of us who are under English law, which has another name, it's called common law. Common law. We are comfortable with trusts. And so that's why in the Caribbean, for example, in Canada, in the United States, in those countries that are subject to English law originally, we have no problem with the concept of trusts. However, you go to Russia and Brazil and Middle East and China and all these places, they are not happy with this thing called a trust. I have to transfer my assets to a stranger, and I can't get them back? Hell no. I want control of my assets, and therefore I will keep them. And when I die, they can fight after that over them based on what I said I will.
Why is it that they can't get them back?
Because that is the law that governs the trust arrangement. I know it's crazy. For example, last time I traveled, no, not even travel, I went to Bahamas to a function. This me pulling out my wallet to pay for the, what do you call it, valet parking. What did they tell me? They said we don't take cash anymore. And I'm like, why not? See, kind of like that. And they said, because not. You know what that means? If you don't like it, you and your stinking car go find parking. That's basically kind of like that. So that's the reason, based on the law of trusts. That's how it works. And that's why a lot of persons who don't like trusts in those non-English common law countries, they don't do it. You go to them, try and sell a trust deal as a trustee, they'll tell you get out their face. They'll listen to you until you get to the part where you said, under trustee lawyers transfer your assets to us, and you no longer own it. We manage it on behalf of your beneficiaries. Once they hear transfer, they don't want that. Because folks normally want to control their wealth. Not everybody. It's folks in certain jurisdictions. Those of us who have become familiar and comfortable with the common law, English law version of how trusts work, don't have any problem with it.
Okay, just for complete understanding.
That's
So
the idea.
once the seller transfers the trust to,
Once they,
once the settler
yes,
transfers the trust to
you mean transfers the
assets to another trust
to a trustee?
to a trustee,
Yeah.
the assets then belongs to the beneficiary. Is what you're saying?
I'm so happy you asked that. This is interesting. This is fundamental to the trust. If you don't really understand this aspect, you'll always be like, limbo with trusts. That's a huge question. Once the assets leave the settlor and are transferred to the trustee has the legal ownership of the assets. In other words, in law, they own them. But based on the trust agreement, they cannot benefit from them. The only persons who can benefit from the assets are the absolutely. So the trustee can't say, thank God I have $50 million in assets from the settlor, I'll just keep 10 million for my, no. The trustee cannot touch those assets for their personal use. You understand? The only thing the trustee can do with those assets, legally own them and execute the use of them on behalf of the beneficiary. And that's why we have the trust deed. Because this is a legal document which binds the trustee to live up to the obligation to what? Use the assets for the benefit of beneficiaries. Only. Not the trustee. The minute that trustee decides to use those assets for their personal use in any way, they will be found to be in breach of trust. And I can assure you, the trustees will come down on them like a ton of bricks. Some trustees have been found to be using trust assets for their own personal benefit. That is illegal. That is a violation of the what duty? Fiduciary duty. Because part of the duty of care is to make sure you don't try and use the assets for your personal use. They're not yours. You only have legal possession, but you don't have any equity in it. You cannot use any of it for yourself. Okay. So that's a very good question. A lot of persons still don't understand that clearly. And when you go to persons in non-common law jurisdictions or non-English law jurisdictions and try to explain that to them, you'll be on the phone for a day, 2, a week, a month. Like, do you get that, Sheikh Monfariki? No, I still don't get it. Because the minute they hear transfer their assets, they shut down right there. And you said, well, Sheikh, or whoever, Xinjiang, those countries. All we're saying is that the trustee, us the trustee, will have legal title, but we won't be able to use it for our personal use. All we can do is use it for your beneficiaries. Do you get it now? No. They don't want to what? Transfer there? Yes. Okay. All right, keep going.
Again, much will depend on the provisions of trust as to who can utilize
Yes.
and enforce.
Well, that's a hell of a. Everybody see that? That should be utilized. I don't know, 17 tins. That's interesting. Okay.
And enforce this power, although normally it will be the trustees. If there is no power in the trust to do this, then application will have to be made to the court under the relevant statute within the existing jurisdiction.
Okay. So now it's a new concept for you guys as well. If the trust agreement does not have provisions for anything whatsoever, where do you go? To the courts. You as trustee, don't try and make up something to satisfy your own personal agenda. Don't. Okay? If you have a question that comes up and there's no provision in the trustee for you to do it as a trustee, don't do it. If you have any doubt, take the matter to court. Let the courts decide it. If you are a personal trustee, let's say somebody comes to one of you and say, Santina, you're the only person in the world I trust. I'm leaving my $50,000 policy and trusting that when I die, you will make sure that it is distributed the way I would like for it. So therefore, that automatically makes Santina what? A trustee. Okay? If something comes up after the death of the person who left the will, the testator who left the will, and Santina is not sure what to do for whatever reason, she should not try and make that decision on her own as trustee. What should she do? Go to the courts and get the courts of feedback on what's the best route to take. Because if she does not do that and something comes up and there's a dispute, then she will be sued potentially by the beneficiary. Okay? Same principle applies on the institutional level with trust companies. Okay, keep going.
In transferring a trust from one jurisdiction to another jurisdiction, consideration will have to be made to the following issues. Although this is by no means an exhaustiveness.
For sure.
The similarities and differences in the trust laws of both jurisdictions.
Okay, so these are the things to consider before you transfer the trust. Okay? If there are too many differences, what do you think you should do? If there are too many differences in between jurisdictions, what do you think you should do? Not transfer. Okay? Alright, for sure. Okay. Number 2.
The interest in the beneficiaries and whether the change of jurisdiction /change of trustees will have any adverse or prejudicial effect on these interests. The interpretation of certain words compared with other jurisdictions, particular attention should be made to any terms of the provision or powers that may be altered because of the change of jurisdiction.
In other words, folks, as a trustee, you need to sit down with your attorneys and make sure you consider all of the possibilities that can jeopardize, this doesn't close, right? That can jeopardize the trust if you transfer it to a new jurisdiction. For example, if you have a trust in your jurisdiction and you're thinking about transferring it to another jurisdiction where the language is not the same, that means when the trust gets to that jurisdiction, the trustees over there might mismanage, quote unquote, the trust according to their way of doing things as opposed to the way you do things in your jurisdiction. And if you see any of these things coming up that could potentially harm the trust, you as the existing trustees need to take action and maybe go to the beneficiaries and the courts and say, we don't think this is a good idea because, okay? And let the courts make a decision. Because sometimes if you transfer the trust to another jurisdiction and it runs into trouble, the beneficiaries might end up suing who? You, and said, in your fiduciary responsibility to us, you ought to have known that if you sent it over there, the Indians were going to thief all of our assets, like take it, because they don't believe in no trust. Okay? And they'll tell you when your assets get there, over here, you don't own anything. Like if it goes to China, you don't own private property in China. You don't own private property in Cuba. Did you know that? Like how you I'm going to buy property. In Cuba, you can't own any private property. Everything is owned by the state, the government. Okay? So all of us who are, oh, I want to go to Cuba and get Cuban. Well, that's one of the reasons why the Cubans would run away, taking over South Florida. It's another story. All right, keep going.
The appointment of a trustee in the new proper law jurisdiction.
Okay, so these are just some of the things that the existing trustee should consider before sending a trust to a new jurisdiction. So when you get instructions as a trustee to transfer a trust, you don't just say yay. You need now you have a whole sit down with your committee or your group and decide all the things you need to consider before you transfer that trust. Because even though the instructions came for you to transfer, if you don't do it properly based on these things and other considerations, you might find yourself in court paying out millions of dollars in lawsuits if you lose. Okay? All right.
Another consideration with regard to the transfer of trust in the existence of a plea clause in the trust instrument, which will have the effect of changing the management and administration of a trust to another jurisdiction on the occurrence of a particular event, political instability, civil unrest, taxation, etc.
In other words, part of the transfer for some trust includes a flee clause. So have you ever heard about the flee clause? Flee means what? Run. Okay? A lot of trustees have a flee clause because the trust might be sitting in a jurisdiction that goes to war. And they can't settle, and they're fighting all the time. Do you want your trust there? Of course not. So they're going to take your stuff. So in a situation like that, you make a provision in the trust deed that if there's civil unrest, political instability, and all this instability, we do what? Transfer the trust. And that clause, where that information will be, is called a flee clause. So if you're reading a trust agreement and you see flee clause, you'll see why that clause is there and what the conditions are for transferring the trust. Even the Bible says flee when you see stuff. And maybe that's where they got it from. Because remember, the trust deed came from what? English law. English law supports the Bible, even though at least they supported more than Thingham in Asia and Africa and all those weird places. Okay. But they have other beliefs. Let me put that way. Yeah. Okay.
The plea clause will normally contain some provision that on the occurrence of some predetermined event,
Such as civil unrest, taxation, war, and so on, yeah.
The trustees will automatically retire and new specified trustees will be appointed in another jurisdiction.
Yes.
It will also state that the proper law and the law of the forum will also be changed at the same time as the change in trustees.
Okay. We're professionals now, we understand what that means. Because you already know what transfer of a trust is all about. This is just one of the conditions under which you might want to transfer immediately. And you may obviously want to have this flee clause in there before the whole relationship is what? Established. Okay, by all means.
The jurisdiction to which the trust will flee should have comparable trust laws to that of the former jurisdiction in order to avoid any possible future conflicts, and it should normally be one in which the original trustees have some representation or office.
Indeed. Okay, don't send it into the jungle somewhere or some weird jurisdiction. Send it to a jurisdiction that has similar laws to where you are. Otherwise, that trust is going to be in trouble. Okay.
It should be noted that new trustees who are appointed under a deed of retirement and appointment should, as a matter of good practice, review the trust laws of the original/former jurisdiction to ensure that they are comparable to those of the country in which they are resident, and carefully vet the provisions of the trustee to make certain that the provisions of the trustee are acceptable in terms of the duties, powers, obligations, risks, and indemnities that will assume in accepting to act as the new trustees of the trust.
In other words, if you're accepting a trust as a new trustee from from an existing jurisdiction, do not accept it with your eyes closed. You have to scrutinize all the details before you say, I do, for getting married. Because if you don't, you might be accepting a lemon, a trust with all kinds of problems. Don't be fooled by just the what? Value of the trust assets and all the fees you can make from the value of those trust assets. That's not your only concern. That's an important part of it because one of the reasons why we are trustees is to make money. That's the primary reason. But you have to also consider, should we take on this trust at all? What are the risks? Okay? It's like when you meet a new guy, for example, and you start dating, because he might be rich, you might say, I straight. I don't have nothing in the world to worry about. I don't need to check nothing on this guy. He has stuff. Then you find out afterwards that your dream guy is a wife beater. He is an abuser. He's a doggone, God knows what, former criminal from the Ukraine, or whatever the case might be. But because you didn't do your due diligence, all you looked at were his
Assets.
So be careful, trustees. And some trust companies make this mistake. They're so busy trying to what? Increase their client base. See? That they fail to look at the details to see exactly what kind of trust are we indeed taking on. Okay? Even right down to the beneficiaries. You have to look at the trustee as the new trustee receiving the trust transfer and said, do we want these kinds of beneficiaries or not? See what I mean? So all the way down even to the beneficiaries of the trust, you have to consider whether it's a good idea or not. Okay, keep going.
The new trustees should also investigate the existing relationship between the original trustees and the beneficiaries.
There you go.
And any administration and accounting issues
There you
that
go.
may pose potential conflict.
And folks, for those of you who have not had the experience of being involved in these environments, they could be very testy and very expensive if you make the mistake of not doing your due diligence. Yes. You have an idea what due diligence is all about in your business. The business that you're in is very, very risky business in terms of who's sending money to who, and where did this money come from, and what is the source of this money. All right, and so this, when you're in the cash business, for example, it's always tricky as to where is this money going and what is the purpose of this money. Okay, and so they try to do the best they could to establish due diligence to try to control the amount of negative and illegal activity that could potentially take place. Yeah, suspicious activity. Same principle for the trustee. Okay, somebody's transferring a trust to you for $100 million. Fine, you can make a lot of money from it, but that's not the only thing you have to consider. They're giving you some ideas. What is the relationship between the trustee and the beneficiary? If it's contentious, you may not want it. What does contentious mean? They're fighting for whatever reason. And if the beneficiaries are fighting with the trustee, before you take that trust, you need to try and find out why. That's why sometimes if a woman is going to marry a guy who is already married, she'll go to the ex-wife like this. Can you tell me something about Tom Jones? Trying to get information or whatever, because she's trying to establish what? Should I do this? And some people don't do that. They say, I don't have anything from that chick. That's her, this me, and so on, and then they say, let's go. But the whole idea is here, and what they're trying to say early in this relationship, in unit 1, if you're transferring a trust, make sure you do your due diligence as a trustee. Okay, and then finally,
The trust instrument. The document which purports to create a trust is known as the trust instrument.
true or false? True or false? Is that a true or false statement? True. Just want to make sure you guys are as confident as I am. The document which, I know purports throw you off, but But any document that creates a trust is a trust instrument. What's the other name for trust instrument? Trust agreement or trust deed. So those are three words I use interchangeably. You should know all three of them so you don't get confused if the question uses one word as opposed to the one you know. Trust deed, trust agreement, trust instrument are all the same. It is the agreement that governs the whole trust relationship. Just like a partnership agreement. If you're going into business with a partner, you should have a partnership agreement. Same thing. It governs the agreement, the arrangement, the deal, the relationship. Okay.
Unless it is a trust created by a will, where the trust will comprise the provisions of the will which mention the creation of a trust, the appointment of trustees, the transfer of trust proper, and
What should that be? Trust property, yes.
and equitable interest of the beneficiaries.
Now this is an important point, so I have to say this. In other words, a trust might be established directly through a trustee, or what we call indirectly through a will. Not all wills become a trust. Some people establish a will and say, upon my death, I'd like for you to establish a trust with these provisions. See what I mean? Some people come in and don't create a trust, they create a will. They create a trust automatically. So you have a direct trust, like deed, creating a trust, or you have a trust being created through a will after the person, after the death of the testator. A testator is a person who creates a will. A settlor is a person who creates a trust. Okay, folks? So you can have a settlor creating a trust directly through the trust deed, or you can have a testator creating a will, and upon the death of the testator, the person writing the will, leaving the will, then you establish a trust for the long term. Because remember, some wills are for the short term and some are for the long term. So if you have $30,000 in the bank at the moment, and you said, whatever, when I die, whatever's in my bank account is for my child, my one child, Susie May. When you die, they write a check, give it to Susie, the matter's closed, isn't it? However, if you are wealthy or you have substantial assets, you may want to then say, upon my death in this will, I want to convert this will to a trust. And under the trust deed, I want my children to get $2,000 a month. Absolutely. From the income of these assets. And then when all of them drop dead, they are children. And all that until what? The money runs out. You follow? And the trust is terminated. The point is to know the difference between the trust deed that is established immediately by the settlor and the will trust, which is established through a will first. Okay? Does anybody know what we call a female person, a female who leaves a will? A male who leaves a will is called a testator. What is a female called? That's a tricky word. Yeah. Testatrix. Yeah. T-R-I-X at the end. Absolutely. Something to know in case you see it along the way. Okay. All right. And then finally?
The trust instrument may be referred to as the trust deed or the trust settlement, depending upon the parties who author and sign the document.
Okay.
A properly drafted trust instrument will include the parties to the trust,
Okay.
the trust property, trustee's duties, trustee powers, certain powers of appointment, the right of the trustee to receive remuneration.
What is remuneration? Yes, payment. Trustees are not doing this free. Normally, in the old days, trustees did not get paid for their work. It was done free. So, does anybody know how trusteeships began back hundreds of years ago? No? Remember during the Crusades when they had a lot of wars in Europe? And these guys would go out conquering. Alexander the Great thing, I'm thinking that. And everybody's fighting each other, taking stuff, taking prisoners, all that crap they did back then. Okay? What happened was, these guys who were going out to war, they did not know they were going to return. Whenever you go to war, only the lucky returns. That's the way I put it for simplicity. Because nobody really knows who the hell is going to get shot, stabbed, blown up, chopped up. In case you didn't think about war like that. So before they left, they said, I may not come back. I have a wife. I have children. I have my mom even. They never died. They never say their dad though. It's never tomorrow's Father's Day. But nobody ever said anything about this gang here. Even back then, I said, I have a wife, children, Mom, I guess if they had a dad, he was a man, you're on your own, like Pat Boone. Maybe if you were young enough, which may have been. Okay? Because if you had a child when you were 20, the child is 20, you're now 40, you still can go to war. See what I mean? Not like me when I had a child when I was 100. So if war comes and not me, I know I'm too old. Right? But yeah, that's a possibility. And even if that was not so, I guess, these people benefit then. Okay. But what really happened was these guys would leave their assets in trust with somebody they trusted. So it was always a what? Personal trustee. And then if they didn't come back from war, then the trustee, their best friend, the person they trust, Reverend Tom Jones, Cardinal, whatever, whoever it was, would then make sure that the family received the assets of the person. Now, be assured that that did not work perfectly. Some persons were honest enough to give it to the family, and others never did. How about that? Which is why perhaps it would have been a good thing in those days if the guy who's going to war leaves them in trust with somebody, tells them that it's in trust with them. But there's a danger in telling them, because once they know they want it, now. So sometimes you can't tell them because of the fight that will break out, but if you don't tell them, then they may never know. But that's another issue. But it is an issue that you need to consider. Because remember, even though you guys may never be filthy rich in your lifetime, you will have some assets, and you will have to make these decisions outside. We're discussing it from an institutional perspective, okay, and from other people. But remember, it can also apply to any one of you. If you have $300 in the bank and you say, when I dead, when I want my $300 to go to, then you're in the same position as Paul. Okay? All right, keep going.
The property draft the trust instrument will include the parties of the trust, the property, a trustee duties, trust powers, certain powers of appointment, the right of the trustee to receive remuneration, the exercise of the trustee's direction, an exoneration clause from liability for breach of trust, the power to make capital and income payments to beneficiaries, and the variation and termination of trust.
Now, folks, if none of that makes any sense to you right now, that's okay. This is just a big mouthful, just to introduce you to the concepts and to let you know that the life of a trustee, whether it's personal or institutional, is not just a walk in the park. And when they give you a bill for their services, they're not doing it just for the hell of it. There's a lot of work involved in maintaining a trust relationship. And to think that back in the day, persons, and even now, persons still do, personal trustees still do trustee work for free. Because that's their friend, a relative, somebody like that. They left it in trust. Oh, you don't have to pay me. I have my own money. I poor, but it's okay, and so on. So these things are still very relevant. All right. So we're going to get into all those different constructions a little bit later. It was just designed to introduce you to the life and time of a trustee. All right. Thank you very much, Rico, for taking us through all that sludge. I know that's a lot to take down, but that's okay. It'll all come together. All right. So, Sabrina, why don't you pick up Unit 2, beginning with the Seth Law. Unit 2 talks about the parties to a trust. There are 3 key parties to the trust. We already, yes. With the exercise it? Oh, the exercises at the end of each unit, here's what I need you to do. I need you to answer those questions. But remember, if you don't struggle through it first, it's no fun. I need you to answer those questions, and if you come across any question that you, first of all, cannot find an answer to, make a note of it. And secondly, if you're not clear on any of the questions that are asked, make a note of it. So that when we come into our next session, that we can get those cleared up for you. Or you can send me a text or an email, one or the other. Okay? So please go, those exercises are there to just reinforce your reading, answer those questions. I was saying to someone earlier, do them. Do not fail to do them. And do every last one of them, no matter how painful it might seem. They're really part of the exercise to get you more familiar and to help you to remember the concepts that you've read. And they're designed to take you back into the chapter, to do the research, find the answers, and solidify in your mind. Okay? And then when we come next time, if you have any questions, please, let's talk about them. We're only going to deal with the ones that you have a problem with, not the ones that you've been able to zoom through. Because most of them are pretty straightforward. A couple of them for you might pose a problem. And that's okay, that's what we want. That's what being a student is all about. You're not expected to know the whole bloody thing right away. Alright. So, parties to a trust. We were talking about them earlier. There are three primary parties. What were they again? Parties to a trust. The settlor, the trustee, and the beneficiary. Something to keep in mind. Something to sing a tune with until it finally settles in your soul. They are the three key parties to a trust. Without them, you have no trust. Two of them are not enough. One is definitely not enough. All three parties must exist. So if you pick up a trustee and you don't say anything about beneficiaries, that's a problem. You need all three parties to the trust to make it a legitimate trust instrument. Did we talk about the C's of trust, the certainties? Yeah, those who are here today may not remember that. But at the beginning, last session, we talked about the certainties of the trust early in the chapter.
Yeah.
Yeah, the three certainties. Anybody remembers what they are? If we go back to the beginning of the unit, three certainties. One of them is the certainty of objects. Must have beneficiaries. Anybody found the other one? Oh, that's
Certainty of intention.
Oh, certainty of intention.
Of subject.
Yeah, certainty of intention. What page is that on?
14.
14, everybody. Certainty of intention to create trust. And the third certainty?
Certainty of subject matter.
Certainty of subject. Okay, folks? So if you get a question like that coming up as an essay question, you don't want to say, well, I never saw that. These certainties are crucial because these three certainties must coexist with the three, what do we call them? In Unit 2. Parties to the trust. Okay? So they must coexist if you're going to have a proper trust agreement. Certainty of objects, beneficiaries, certainty of intention to create a trust. The document must say it is my intention to create a trust. If you write up a whole document and don't indicate that's your intention to create a trust, somebody might come back later and say that trust is a sham. It's not a real trust agreement, and throw it out. And you're back to square one. There's a lot of legal wrangling going on in the trust world that you may not be aware of, and part of the reason is because some trust instruments are not done sufficiently and correctly, and then beneficiaries find out about it, and then there's a dispute. Okay? So the trust deed must indicate who the beneficiaries are, that is the intention of the settler to create a trust, and whatever the subject matter is in that trust. So revocable, irrevocable, and so on. Just something to keep in mind. Okay, Sabrina, so pick it up for us, beginning with settlor.
The settler, who is also referred to as the grantor or donor, is the person who originally has legal and equitable title to property and transfers assets into a trust for the benefit of another person or person.
Which we talked about already. Now you just know that there are the two other names for the settler, and they are donor and grantor. Depending on who you're talking to, which jurisdiction you're in, they may use any one of those three. So if somebody says something about a donor, you say, man, I don't know anything about donor, I never heard it. Yes, you did. Donor is the same as settlor. Grantor is the same as settlor. Okay.
In instances where a trust is created in a will, the settler.
Excuse me, the will, remember the will trust? Is that 1 or 2? Number 2. How is a will trust established? Anybody remembers? Testator leaves a will with instructions, yeah, to create a, absolutely. And that is different from a trust deed where a what? Settler directly establishes a trust. Absolutely. Very important difference. Okay.
The settler will is referred to as the testor or testatrix.
Oh, that word, testator or
Testatrix.
testatrix. Yes.
If it is a woman creating the trust in the will.
Which one is the woman?
Testatrix.
Okay. Remember, these things are not necessarily words we hear every day, so don't worry about them. You just keep what? Practicing them until they drop off your lips. Until then, don't worry about it. You just keep practicing them until you get it. No big deal. Okay.
A trust is an inter vivos.
Okay.
Trust.
Vivos, yes.
Vivos trust, where a settler creates a trust during his lifetime.
Stick a pin. So when you hear testatrix, now you know what's going on. Even if you're walking past and think I'm drunk and you hear that, you're like, because now you know what's going on. That's the beauty of information. Even if you don't work in a trust company yet. See what I mean? When you hear that word, say, wait a minute. I need to listen a little longer. What's going on? Okay? When you hear words like inter vivos now, what is that? Yeah, it means that the settler creates a trust during his lifetime. It's a Latin expression. Vivos means life. Okay? Remember here in Spanish, like viva? That means life. Saying it comes from Latin as well. So the trust inter vivos means the settler has created the trust in his lifetime. Okay.
Okay, and a testamentary.
Yes.
Trust, where the trust is created in a will made by a settler.
Okay, okay. So if you hear inter vivos, it's the trust and testamentary is the will side of it, the second part. Okay. So you have some new expressions to consider. Okay.
The legal interest in the assets is transferred to the trustee, who becomes the legal owner, and the equitable interest is transferred to the beneficiary, who becomes the equitable owner of the assets.
We've said that already? Yes, we have. If you have to read it a couple of times in your own time to get it, that's okay. But accept it as fact, because that's the way it has always been and continues to be. When the settler transfers his assets to the trustee becomes the legal owner only. And the beneficiaries become the equitable owner only. In other words, the trustee has no equity in the assets, they cannot use it for their personal use. And the beneficiary has no legal interest. They can't take it and say, give me my daddy's stuff. They can't. All they can do is benefit from it. But they can't take possession of it. Because they have no legal right to it. It's a fascinating concept. Okay.
Notwithstanding the fact that the settler may be the client of a professional trustee who is responsible and contracted to pay the annual fees for the trust. Once a trust has been created, a settler has no rights regarding the rights and regarding the trust unless he has reserved such rights in the trust instrument. as in Section 3 of the Trustee Act 1998 and the Trustee Amendment Act 2011.
Now, let me just say something for the new kids on the block. The Trustee Act 1999 and the Amendment of 211. Please Google it, have a look at it. You're not going to be required to know the acts by heart, but you are required to know that the acts exist, the act and the amendment. So you want to Google that, have a look at it, see what's in there, and especially where there's reference from your textbook, pay attention to those references. Have a look to see if what is referenced here, actually you can find it in the Trustee Act, because the act and the amendment is what governs all trusts agreements in the Commonwealth of the Bahamas. And here's why that happens. The trust deed is the legal document that governs how trusts are administrated in the Bahamas. The Trustee Act and the amendment of 2011 is what we call the statutory document, or law, statutory law, which is passed through the Parliament. That's why we call it the Act, like any other law. Okay? So trusteeships in the Bahamas are governed by two key instruments. First, by the trustee agreement, settlement, and secondly, by the statute or the act. So the trustee, something comes up and the deed does not make provisions for it, you can go to the Trustee Act to see whether the law makes provision for it. Does everybody follow that?
Yes.
And if you can't find any provision in any of these, where do you go? The court. That is your last resort. Whatever the court say, dog eat everybody's lunch. So theoretically, if you can keep it out of court, you should always do that. But if not, that is your last resort. Alright, so do take a look at the Trustee Act. You don't have to read every single detail or know every single detail. That's not the idea at all. Just know that it exists, and where there's reference made to it in your text, go into the act and see if you can find that reference and see what it says. Okay? All part of the classroom misery. But hey, that's okay. No pain? Absolute pain. Okay.
Therefore, the settlor cannot vary or modify the terms of the trust, appoint trustees, remove trustees, exercise discretion on the payment of trust funds, or terminate the trust, unless these powers have been expressly reserved within and directed by the trust instrument.
Now, this is a tricky situation, folks. It's funny, because especially if you're new to trusts. What we're saying here is, once the settlor has given up his assets to the trustee, the settlor no longer has any legal right to those assets. But there's a caveat. And the caveat is this: unless the jurisdictional law or the trust instrument makes what? Provision for it. What that means is this: even though that's the rule, once you give up your assets, you cannot touch them anymore. In modern trust law, the reason why we say modern, because in the old days, like 50 years or more ago, going back, it didn't exist. Once you transfer it, that was it. Dog ate your lunch. If you wanted it back, you can't get it. Under modern trust law, you can make a provision in the trust deed as a settlor to actually get back or control certain aspects of the trust, if it's in the agreement. Do you follow that, folks? If it's not, the old rule applies. But if it is in the agreement, some settlors can still what? Manage and control and run the trust because of the agreement that is there in the deed. Now, a lot of jurisdictions are not happy with that. In Bahamas and others have provisions for that in our Trustee Act, and many in the Caribbean, because what happens is, the argument by many beneficiaries nowadays, if the settlor has too much what? Input in the trust, then he or she starts to control it. And if they're controlling it, why do they need a Absolutely. Which means that technically the trustee might be what? Irrelevant. And this is where we have the question of when that happens too often, the trust is deemed to be a sham. Anybody ever been in a sham relationship? Like it wasn't what you thought? Come to find out it was an egg. He really didn't care. Like that. That's a sham. So if the trust, the settlor has too much control of the trust, eventually a beneficiary or somebody can say, wait a minute, we need to shut this trustee thing down because it's a sham. It's not really a real trust as trustees should work. Okay? So even though we have this provision where the settlor has certain powers to help the trustee and be involved with the trustee's decision making in the trust, we have to make sure in jurisdictions like ours that we don't allow the settlor to go what? Too far. Who should make the primary decisions? Absolutely. However, if it is ever seen that the settlor is really making too many decisions, then that trust could be deemed to be a or fake. We're just setting it up a trust so that we can get other benefits, but it's not really what? Acting like a trust. It only looks like a duck. But it's, yeah, but it's not really a duck. Same principle. Okay. I just thought I'd throw that out initially. But that is the after side of the real way a trust should work. And the real way a trust should work essentially is that the settlor, once the transfer is made, gets out of the picture. Period. Okay.
The settlor may issue letters of wishes to the trustee which in effect stipulates his wishes in relation to how the trust should be managed and administered. However, though the letter of wishes provides practical guidance to the trustee, it is not legally binding and is not required to be followed by the trustee.
Everybody's clear on that? Every trust agreement is accompanied by a letter of wishes by the settlor. The letter of wishes will indicate, I would like for the trustee to make sure that my wife is taken care of for the rest of her life. I'd like to make sure that any disabled children I have are given special care until they die. I would love for my pet parakeet to be fed and not murdered prematurely. I would like for my dog to have preferential treatment to be given a bath once every week, and so on, so I to get his nails did, and so on. That's in the letter of wishes. However, in law, the trustee does not have to follow the direction in the letter of wishes. The only thing the trustee has to follow in law are the provisions of the trust deed. If it's not in the trust deed, they have to follow the provisions of the Trustee Act, which is a statutory act. And if it's not in any of these two, then they go to court. But certainly they don't have to follow the letter of wishes. But those are there because the settlor wants to give the trustee an indication of what he would like to see happen in this arrangement long after he or she is dead. And even in their lifetime before they're dead. Okay? Because remember, all settlers are not dead right away. We have inter vivos trust, right? Living trust. Right? Okay, keep going.
A settlor may have certain rights under law. As a beneficiary, the right to information under Section 83 of the Trustee Act 1998 of the trust, but only in his capacity as a beneficiary.
Now listen carefully. Normally the trustee has no rights. Sorry, the settlor has no rights. Once the assets are transferred over, he goes fishing. Shut up, leave the trust to the trustee. However, under modern trust law, such as in the Bahamas and this side of the world these days, the trustee may have a provision in the trustee where the settlor can actually be a beneficiary as well, which is very modern. In the old days, it never happened. Never even come up for discussion. Nowadays, a settlor may list himself as one of the beneficiaries. And therefore, as a result of that, the settlor can make provisions for them to get what? income benefits like other beneficiaries, get information on the trust like other beneficiaries. If the settlor is stated to be a beneficiary. If the settlor is not a beneficiary in the trust deed, they are not entitled to any of the benefits that other beneficiaries get. So that's a modern law provision where a settlor can now actually be a beneficiary. Once upon a time in trustee relationships, never happened. Old trustees from back in the way, back in the day when it's early as 50 years ago, if they saw the modern trust law that allows the settlor to be a finished beneficiary, they would have 17 babies and 2 cats. Why? Because under the original and common law, the settlor could never be a beneficiary.
Isn't that just them monitoring the trust? I mean, that's a way of monitoring the trust also.
That's the modern way of trying to burn the candle on. Yes. Yeah, for some of them, it's a form of monitoring. But theoretically, there are other ways to monitor other than being a beneficiary. But then being a beneficiary also gives them some other provisions. They can, get information like other beneficiaries to monitor what the trustee is doing. They can get payments out of their money, their wealth directly as a beneficiary, and so on. So there are a lot of different reasons why this provision was allowed and continues to happen. Okay? The whole idea is to make sure, as far as possible, that with all of these new provisions to the trust agreement, that the settlor is not seen to be controlling the trustee. Okay? It's like, guys, I'm in charge of the house. Who's really in charge? His wife and children. It's kind of like that. Okay, keep going.
The settlor does have certain contractual rights based upon his client agreement with the professional trustee, confidentiality, professional care, and skill. However, as it relates to the trust itself, it should be noted that only the beneficiaries may sue the trustees for any legal breach, including a breach of trust. The settlor may
Only the beneficiaries may sue. Okay, that's something to keep in mind going forward. Okay? The settlor cannot sue the trustee, no matter how dissatisfied he might be, unless the settlor is a what? Beneficiary. Under modern trust law. Remember, before trust law became modern, the settlor could never be a. Absolutely. But because of modern trust law, in some jurisdictions, not English, not in England. In England, they still follow the original common law. Okay? They don't.
Excuse me.
They don't do this stuff that modern trust jurisdictions do that make settlers what? Beneficiaries. We do that in this part of the world. But in the UK, for example, they don't do that. Settlers still cannot be a beneficiary. Alright, but that's something to keep in mind under modern trust law. Okay.
The settlor may act in the capacity of a protector, an individual/executive entity with the responsibility to oversee and supervise the actions of the trustees and in certain instances provide his consent under the terms of the trust instrument. He may also be considered a power holder in his capacity as a protector, which has certain implications to the trust.
So now in modern trust law, the settlor has all kinds of little subtle privileges. He can be a protector, and later on you'll see that the protector in the trust is the person who is assigned to what? Watch the trustees and make sure things go according to plan. So usually the protector is a separate person other than the settlor. But nowadays in modern trust law, the settlor can appoint himself as and some other crap, which is very, very modern and very, very interesting. Okay? So it provides a kind of flexibility that the original common law made no provisions for. Okay? That's why we refer to it as modern trust law. Modern. Okay?
Okay, so do we allow the modern trust law in the Bahamas?
Yes, the entire Caribbean. Okay? The Bahamas, Cayman, BVI, All those jurisdictions have modern trust law provisions. One of the few countries that have the original position would be the UK and maybe Australia, perhaps Canada, those kinds of common law jurisdictions. But the Caribbean has a whole lot of modern trust law.
Is it because we deal with so many American,
Non-Americans in particular, okay? Um, but what we're trying to do because of competition and all this stuff, we come up with these new provisions so that we can what? Attract absolutely more business. The only problem is you have to be careful that in attracting business, we don't attract the malware that comes with it, potential sham trusts and other problems that come with it. By all means. Okay.
Under Section 13 of the Trustee Amendment Act 2011, TAA, which
What does
inserts
CAA mean?
Trustee Amendment Act,
Okay, just checking.
which inserts a new section 81A into the Bahamas Trustee Act 1998 for settler-directed trusts in relation to investment powers. A trustee may be absolved from any liability for the loss to the trust where he has acted on the instructions or directions of a power holder or failed to act in the absence of a direction from a power holder with responsibility for investment.
Now, folks, again, it's interesting that we've gone from the old common law to the modern trust law because this is where we are in the jurisdiction, this jurisdiction and many others in this part of the world. Okay? So this is just another example where a settler may find himself acting as a power broker, meaning the settler makes provision in the trustee under modern trust law that he would be the investment manager for the assets of the trust. Normally, the investment manager would not be the settlor. It would be some other professional appointed by the trustee. The settlor is not the ideal person to be the investment manager unless the settlor has what? Investment management skills. Do you follow? And so where the trustee makes provisions for the settlor to be an investment manager, and then settlor does not have the skills to do that job, a trustee is putting his operation in jeopardy. Because if something goes wrong, the beneficiaries can then sue the trustee for breach of trust. Because they can say that the settlor, who is the investment manager, messed up their investment, and the settlor was never trained in investment to do the job. So the trustee made a what? Poor decision. Do you follow how that works out? So yeah, it's modern, it's convenient, it brings new business, but every trustee who does this kind of stuff has to be very careful and know that there's liability sitting out there if something goes wrong. As long as nothing goes wrong, nobody has a problem, as usual. But when something goes wrong, see, all hell breaks loose and everybody's looking to run for cover and blame someone. This thing. So in this case, yeah, the provisions are made for the settler to be an investment manager for the trust. That's not the ideal situation unless the settlor is what? Trained. If not, the trustee should not mess with that. But some settlers still pressure the trustee to let them manage, run, and do certain things that they should not allow them to do. But under modern trust law, we make certain provisions in the agreement where this can happen. Not only can the settlor act as an investment manager for the assets of the trust, but also that the trustee is absolved of any wrongdoing if something goes wrong. And that's fine on paper. Remember, you can put what? Anything in the agreement. But if something goes wrong and the beneficiaries decide to sue the trustee, they're going to take everybody to court. And then everybody will then be at the mercy of the judge, the new high judge, what's the new chief justice of the Bahamas, yeah. Whomever the judge is. Yeah. That should be interesting. Okay. Alright, and then finally,
Under the provisions of TAA, a power holder is defined in Section 18 of the Act as any person holding a power in relation to a trust, including a power of appointment, consent, direction, revocation,
Mm-hmm.
or variation, and any power to appoint or remove trustees or power holders, and includes a person in the position of a protector.
Thank you very much. That's a lot of power under modern trust law. Under the original trusts, you didn't have that power. Okay? The real power was with the trustee and the beneficiaries. The trustee because they were the only ones who managed the trust, and the beneficiaries because they're the only ones who could sue the trustee. Now the settler has so many other provisions under modern trust law, so they set up a trust and they're deep in it. Theoretically, they shouldn't be deep in it, they should be deep out of it. But under modern trust law, they're deep in it. And because the competition is so fierce for trust clients. Question? Oh, yeah, because the competition is so fierce, not necessarily fierce within a particular jurisdiction, like between Scotia and UBS and Farm Jones here in Nassau, but fierce what? Throughout the jurisdictions. Because remember, all these jurisdictions around in the Caribbean, around the world, are fighting for what? Clients. Okay? And so the modern trust law has evolved to make the trust business more attractive in certain jurisdictions as opposed to other jurisdictions. But again, like everything else, when you try to make something more attractive, sometimes we have malware attached to it. And so we bring over somewhat undesirable situations as well. Be careful. All right, thank you very much, Sabrina. Miss Moss. What's Miss Moss' first name? Lashad. Okay, Miss Moss. You weren't here the first time.
No, I wasn't.
Okay, why don't you introduce yourself real quick? Tell us who you are before you begin.
Sean Moss, I work at CIBC First Program.
Trust or retail?
Retail.
Okay. And you're doing trust because?
I have some interest in it, so I
Indeed.
wanted to go deeper in it.
You know that CIBC has a.
Trust company, yes.
Indeed. So you have options already.
Yes, I do.
Absolutely. Unlike other persons who are trying to get. Oh. Do you know what networking means?
Yes, I do.
Okay. And sometimes when you need networking, you have to talk with persons who are.
Where you need to be.
Mm-hmm. I'm just being the devil's advocate. She's interested in getting into the trust business. So now somebody right behind you, a colleague now, said, "Oh, okay." So he said, "Yeah." A word to the wise is okay. Okay. Thank you very much, Ms. Moss. Let it rip. The second party to the trust, the trustee. Okay.
Okay. A trustee is a fiduciary, which is one who is placed in a position of trust and confidence and acts on behalf of another person or persons.
Indeed. Now you know even more the duty and functions of a fiduciary. Now, again, doesn't have to just be an institutional professional trustee. It can be with a personal trustee has the same duty. And most of us in our everyday lives have the same duty as well, don't we? When we do things, when we do stuff, we should do it with care, as if it's our own, and not try to get over people and run off with their stuff. The problem is a lot of people are not involved in the fiduciary thing. They're always looking for ways to get over. Okay.
The fiduciary owes certain duties of loyalty to the person or persons for whom he or she is acting. Additionally, a fiduciary should act in good faith in relation to the person or persons for whom he or she is acting.
So, as a trustee in particular, and as a fiduciary in general, meaning everyday life, we have to act with a certain amount of care and good faith that will not harm, whether it's our client, the settlor, and the beneficiary, or whether it's our neighbor or a relative or whomever, or even in our capacity as a personal trustee. Okay? That word fiduciary is a very strong word. Okay.
As a fiduciary, a trustee is prohibited by law from profiting from their position as trustee.
Hello? Need I say more? Future trustees and current trustees? Some trustees start thinking that the trust assets are
There's
in a way. So they start manipulating it and doing stuff for the benefit of the trustee, whether it's personal or institutional. You cannot do anything that's for your own personal benefit, period. That is illegal and unacceptable, and when beneficiaries find out, they will sue you. And if the courts discover that you are doing stuff for your own personal benefit, dog eat your lunch as a trustee. They will fine you. They will make you pay. And if it's serious enough, they will imprison you. My. Okay.
He must not place himself in a position where his duties to the trust conflict with his personal interests.
Mm-hmm.
However, it should be noted that a trustee may not be remunerated for his services unless authorized by the trust instrument and/or the court allows him to be remunerated for a fair and just amount for his time and effort in the administration of the trust.
Kiss my foot. Let me just stick a pin, folks. Especially for those persons who are not involved in trustee stuff yet. Because remember, we're not just talking about, we're talking about,
Personal.
it could be any one of you when, anytime. Because you might take on a trusteeship for your friend. She might be dying of cancer, and she calls any one of you, right? And said, I have 2 little children, I'd like for you to look after the affairs for them. Would you do that for me? And when you say yes, you become a what?
Trustee.
Whether you believe it or not. Which means that you are subject to all these fiduciary and other responsibilities as a trustee. And so that means if the friend dies and leaves some money, you can't use it like to take care of your own children. You can't say, no, you have to use the money that she left to take care of her children. If you're acting in good faith. And if you don't have an agreement with the person who's dying, or the court has agreed for you to be paid, you can't take out any money and say, this is my payment for my services. According to trust rules, you have to get it agreed to. So if the person dies and you don't have an agreement, you have to do it free. If you don't want to do it free, you as the trustee have to now go to the court and say, I have this trusteeship responsibility. I can't do it free. It costs me this, this, and this. And the court hopefully will allow you to take out of the trust fund and what is reasonable and fair. Like gas money, working like that. And they might agree for you to get something out of it. But you cannot theoretically do it of your own choice. It has to be agreed in writing between you and the settlor, person who's dying, or the settlor in this case, or the court has to approve the remuneration. So theoretically, this trusteeship was a bunch of stress without pay. Of course, institutional trustees are not going to operate that way. They have bills to pay, staff and other things to pay. So obviously, with millions of dollars coming into trust, they're going to get trustee fees. And they're going to make sure that that agreement is done when? Up front. That's the only reason why they're in business as institutional trustees. Otherwise, they tell you, hell no, I'm taking all that responsibility free. Are you kidding me? Okay. And how would they pay their staff and their bills and their taxes and their utilities and their rent and their whatever it is that institutional trustees have to pay? But if you're a personal trustee, you're not legally obligated. You can't just take out and say, this is my pay for what I do. You better have an agreement. Because if the beneficiaries find out you're taking it out, they can sue you. And take it out of your personal money. If the court says you're in breach of trust and you don't have any, they can take it out of your personal wealth to pay the beneficiaries. So being a trustee, okay, a word to the wise. Keep going.
As the legal owner of trust property, he has certain duties and obligations in relation to the preservation and protection of that property, and in relation to the beneficiaries on whose behalf and for whose benefit he holds the trust property.
Okay, trustees, now you know what your position is. That is your fiduciary responsibility being explained to you again. That's how crucial it is. Another point, these references to cases, I think I said last time, please, you don't need to know all the case in detail, but do find the cases, they're all online. Read the opening paragraphs of what the case is all about and the decision by the courts at the end. And then see if you can tie in the reference in your text to that particular case. By the time you read the opening paragraph and the end, the outcome of the case, you should be able to say, oh yeah, under Foster versus Spence in 1996, it does have something to do with the fiduciary responsibility. And again, that's part of the research side that students do over coffee while the world is having fun. Remember, your fun in life begins when? After August the? Just a friendly reminder in case you want to have fun while you study. You could, but it makes things a little more difficult for you if you have too much fun while you are studying. Because fun leaves you tired, distracted. Most of us work, so that's enough stress. Okay, keep going.
The trustee may be appointed by the settlor in the trust instrument.
I'm sorry, there's another typo there?
Mhm.
Yes, so somebody throw an E there if you don't have it.
At the creation of the trust. During the trust to replace a trustee who has died, resigned, or been removed, or by the beneficiaries and or court, under certain specified conditional and in some exceptional circumstances. The trustee of a testamentary trust by appointed.
Yeah, she
Anyway,
said that's by what?
by
Should that be a point what?
appointment
Yes.
under the
Don't
will.
be afraid to make the change right then, because tomorrow you might say, point it again? Why should have made that change yesterday?
Appointment under the will of the testator, which essentially takes effect on the death of the testator. Once appointed, the trustee will be required to act in accordance with the trust instrument and trust law in general, as developed by common law cases and statute. Trustee Act of 1998.
So the statute law is the Trustee Act of 1998. Common law is the law that governed trust from the very beginning, the Old English law. It's important to know the difference. Okay? Common law is the non-statutory law that was developed from the inception of trust law, and the statutory law is the actual legal position under the Trustee Act of 1998. Does anybody remember when the amendment took place under the Trustee Act in the Bahamas? 2011. Absolutely. All right. Remember, what is the testamentary trust again? A trust that is developed out of a will. The trust is created when? After the testator dies. Good little things to know. Okay, keep going.
In the course of the administration of the trust, the trustee will be given certain duties and powers. He is obliged to perform his duties under the trust in accordance with the provisions of the trust instrument.
Yeah, you mean this. Yeah, any one of those words the same. That's the first thing the trustee always looks to. Always. Always. Then, if there's no provision in the trust instrument, then the trustee will go where? To the Act, to the Trustee Act of 1998 and any amendments. Now, when we say the trustee will go there, that doesn't mean the trustee may physically go there, who works in the institution, or the trustee in the institution, like CIBC Trust or Scotia Trust or whatever, may just call its lawyers, who they pay a bunch of, and say, you go to the bloody Act and let us know. That doesn't mean that the trustee who works in the firm cannot go as well. Maybe save some money perhaps. Okay? Or if there's an on-site attorney that you have in your organization, you can refer to that person who's an employee. The point is, if you don't see it in the deed as a trustee, or some organizations call them associate, but it's a trustee or the trust officer. If they don't see it in the deed in managing that trust, let's say an instruction comes into the firm, to the trust officer, and they look at the instruction and say, do we have the authority to do this? Where would the trust officer or trust manager go first? The trust deed. Read it. I don't see any provision for us to send $30,000 to Xinglai Lu in China. You follow? Yes, well, okay, maybe it's in the Trustee Act. No provision. If you don't see it in the Act, then you go to. And now if the court say yes, you can pay, or whatever the situation is, you can go ahead and.
Whatever the case, the trustee must act and exercise his discretion and decision-making powers in the best interest of the trust and in equal and fair treatment of all beneficiaries.
Does everybody get that again? That's just another reminder that you should be acting in your capacity as a trustee always. And we keep saying it in different ways so that trustees, in this case trust students, as budding trustees, see? Do not forget that whenever you sit in front of a client file, you have to be thinking fiduciary responsibility. Everything I do as a trustee, personal or individual, must be in the best interest of the beneficiary and not my. That's a deep thing. For those of you who are not maybe not actually in the middle of things yet, may not trigger anything yet, but once you get into the real world, you'll begin to understand why that is so critical. And as you move up the ladder and become more senior and involved in trustee issues with the gazillions of dollars, you can see why it becomes more critical. Because the higher up you go, the more you see about things that you could control for your own personal gain. All right. So now we're down to the general duties of the trustee. As you can see, the list is long. It is not exhaustive, but it's long already. Okay. Let's just run them down real quick. But know that it doesn't stop at number 12. This is just to introduce you. These are the key ones. There are a whole lot of other little bits and pieces that you'll come into in due season. All right, duty number 1.
To get trust property into the trust.
So when some settler says, I want to create a trust, you're not really finished until the property is where? In your possession. Legally, not physically only. Legally. Meaning that all the paperwork has to be signed by you and the settlor. Because sometimes some settlers come to set up a trust and stuff is sitting in limbo somewhere. You sign as a trustee, the settler hasn't signed it yet. You keep calling him, John, when are you going to sign? Soon, soon, soon. Well, until he signs, you don't have an agreement. You don't have a trust. Wow. Because sometimes settlers get into something and they want to change their mind. Or they want to forget not to sign on purpose. So when push comes to shove, they could say, I never. And you in the heat of the moment thought that it was all signed. You throw it on the fire, nobody's looking, because that's what the norm is. And then suddenly, 3 to 5 to 7 years later, something comes up and you find you don't even have an agreement. Wow. All right, to get the trust into the property legally, yes. Number 2?
To familiarize themselves with the trust instruments.
Why is that second and why is that important?
Because you need to know
Yes, you need to know the rules as trustee. Otherwise, it can cost you your reputation, your organization, and a bunch of money. Correct? If you make a mistake and send $17 million to the wrong beneficiary and they disappear, how about that? Everybody's just having fun. Wiring, sign here. I have to go to London, I'm busy. Everybody's signing stuff. What the hell are you signing? All of a sudden, the 17 million goes to the wrong beneficiary. How do you get it back? Well, first you have to find them. Or if you have a trust officer or trust senior who's up to no good, they may make arrangements for instructions to come that nobody's checking, and then you wire money to someone they know. Because nobody's following the stuff. And then they get a kickback. Why not? I'll arrange to get it to you. Give me some money and send it to my account down in BVI. How about that? Crap happens. You'd be surprised. And sometimes we don't know until what? All hell breaks loose. Absolutely. Yes, beneficiary complains that I didn't get my check last year. And then somebody says, yes, we send it every year. So I didn't get it. All of a sudden, it didn't go to that beneficiary. It left the account, but it didn't go to the designated beneficiary. So, familiarization with the instrument, crucial. Number 3.
To administer the trust in accordance with its terms.
Because if you don't do it in accordance to the terms, you are in In breach, by all means. Number 4,
to act in a fair and impartial way to the beneficiary.
why impartial? As a trustee, you cannot have any favorites. If one beneficiary takes you to Waikiki, that doesn't mean you're free to give them any special treatment. You follow, trustees? Okay. If you follow everything until you get the, maybe I'll take it to Waikiki free. And we're not always aware that they're trying to what? Set us up. Yeah. Right. Yes. Okay. Taking gifts from beneficiaries as a trustee. Going on trips with their family. Everybody's having a ball. It may be nothing. Or it might be everything. Okay. Trustees. Okay.
In other words, he must treat all beneficiaries fairly and take into account their respective needs.
No favorites. Yes. Number 5.
While the trustee is not under a duty to distribute the income or capital, he must consider whether to distribute the income or capital on a regular basis.
My. So that's another new and interesting thing. He's not under any direct obligation unless he is instructed. In other words, if it's a discretionary trust where he can distribute as he feels, he doesn't have to distribute anything in his discretion. So I'm not distributing anything. He's all capital. And nobody can theoretically touch him. Now, if the trust says these are instructions that then you have to do it. But other than that, he doesn't have to, which is interesting. It's just like companies are paying dividends. Companies are not obligated to pay you dividends. They pay dividends whenever they feel like it. So if you're a shareholder in a company, you can't make them pay you dividends. You have to wait until they pay you. Okay? Kind of like that. Okay.
To keep trust accounts.
We all know why that's important, and it's all too often not done or not done properly. Okay, number 7.
To provide the beneficiaries with information in accordance with the trust instrument and or applicable trust law.
Okay, and the reason for that is some trustees try to keep information from beneficiaries that they are legally obligated to give because they're hiding stuff. They don't want beneficiaries to know certain things about what they are doing. And if the law provides for it or the instrument provides, the trustee must act. Okay? Of course, the trustee doesn't have to give all information. There's certain information that's protected. But that information that is not protected, they are obligated to give. Okay, number 8.
To exercise reasonable care and skill in the administration and management of the trust. To invest in investments authorized by the trust instrument and or applicable trust law.
Indeed. In other words, there should be no investments that are not authorized. Again, the trustee is to be governed by the deed. If the deed has no provisions for investment, you can't say, this is a stupid deed. I'm going to invest it in my capacity as trustee. You can be found in breach. If you have assets sitting and there's no provision to invest, then you have to go to the act to see if there are any provisions. To find a loophole. You follow? If you can't, then you go to the courts and complain to the court. Excuse me, I'm a trustee with assets that are just sitting. I have income to pay to beneficiaries, but how am I going to get income if I can't invest the assets because the trustee makes no provision for investments? Okay, folks? All right. Number 10.
To protect and preserve trust property from unnecessary loss.
A word to the wise is sufficient. If you have power to invest, don't invest it in bad investments. Okay? If you're a trustee in the Bahamas, would you invest in the new IPO that's coming out by the gambling companies? Would you invest beneficiary money in it? As a trustee? They say you can buy shares soon. Would you buy shares?
No.
As a trustee, you have to be careful. Not that they don't have legal position to offer shares, but a trustee cannot only consider what? Whether they have a legal position to offer shares at a gambling company, but what are the other implications? And what impact can that have on the investment returns for the beneficiaries? Okay? Some beneficiaries might get wind of it and say, we don't want our money invested in a, and then all of a sudden you have a big fight on your hands. All right, number 11.
To act in good faith in the best interest of the trust.
Fiduciary again. And 12.
To make no secret profit.
Excuse me?
To make no secret profit.
Why would they say that, I wonder? If a trustee is acting in good faith as a fiduciary, the thought of making secret profits should never come in his mind. But we know that people being who they are, some people are always looking to get away with something.
I
Always.
could invest in a company that I may have some connection where I could benefit from.
Happens all the time. Even as we speak, somebody somewhere is planning some secret gain. Okay? Even spouses do it to each other, planning secret gains. They don't tell the other person. My left hand doesn't know what my. Yeah. And they're married. They sleep in the same bed like this. Like that. For whatever reason. So imagine if that can happen at that level, at the personal level, it certainly can happen at the institutional level. Okay.
The trustee may delegate certain duties to another person if the terms of the trust instrument allow him to do so. However, he may not delegate his discretionary powers to distribute to a beneficiary.
Absolutely.
And he may be liable for loss suffered by the trust due to the reckless and negligent actions of the agent to whom he has delegated his duties.
Absolutely.
If he did not take proper care to appoint or select the agent properly and supervise him adequately.
Thank you very much, folks, trustees. So yeah, you might get an investment manager to invest the trust funds. You might delegate certain other responsibilities that you have as trustee. But even though you delegate it to someone else to do it, an investment manager, an accountant, a lawyer, tingum and tingum them, the responsibility is ultimately yours. So your job is to make sure you monitor them, to make sure that they're properly qualified, they're not jailbirds, they're not crooked, they're doing the work according to schedule. Because if something goes wrong, the beneficiaries are not going to go after the agent. Yes. They're not going to go out. You can't say, well, the devil made me do it, they messed it up. You could say it. But they're going to sue you. Because the ultimate responsibility still lies with the trustee. And if the matter goes to court, the court will not hear from the agents. The court will want to hear from the trustee. Okay? For sure. All right, thank you very much. Santino, are you in the mood for reading? That's his line. That maybe folks may not be able to hear Santina today. Doggone it. Santina, read the first paragraph. Let me hear how it sounds. Hell no. Thank you very much, Santina. I'm going to put you on the hook next time we meet. I understand, no problem. Rest your voice so that next time you can blurt out stuff for us. Thank you very much. That brings us back to Rico. You have to pinch it for Santina. Oh, or if you want to, you can delegate it to this youngster over here. You want to delegate?
The beneficiary.
I'll read. Doggone it.
Who has the equitable interest in trust property, and on whose behalf the trustee acts in the administration of the trust.
And we know that. The whole trust thing was set up by the settlor through the trustee for the benefit of beneficiaries. It's the third party. Okay?
The beneficiary may be an individual who may be identified by name, John, or by description, my son.
Yes.
Beneficiaries may also be specified groups of persons, example,
Children, yes.
nephews, nieces, etc.
Indeed.
The beneficiaries may also be known as a class of beneficiaries comprised of the settlers' heirs, meaning
The settlers. Who knows that?
heirs,
Yes.
meaning anyone who is entitled to inherit property on the settler's death or his issue, which is any descendants of the settler.
Indeed. So his children, his grandchildren, his great grandchildren, and on until the assets run out, or until the descendants run out. Which do you think will run out first, the assets or descendants? Depending on what it is, it's hard to tell. Yeah, absolutely. Okay, because some legacies, some trusts are actually hundreds of years old. Do you know that? Some trusts that exist today are actually several hundred years old. They've been around forever. Old family business brought forward from generation to generation, from century to century,
What about, properties
and especially properties. Absolutely.
and land?
Land, buildings, businesses. Absolutely. Investments, things like that. Okay? For example, Microsoft, imagine if there was a trust set up for that. That'll probably be around a mighty long time. Yeah. All right, keep going.
Beneficiary or class of beneficiaries is the object of the trust since he or they are the object of the settler's wishes.
By all means. So when a settler comes in to set up a trust, they usually have one person or group in mind, and they are called beneficiaries. Let me just say something before we're done, because I need to do the housekeeping. Not this Monday, next Monday. Which date is that? Anybody has a? Not Monday coming, not day after tomorrow. The following Monday, 24th of June. I need to ask you guys: would would everybody be available on this Monday evening for class? I'll tell you why in a minute. Okay. The reason why I would like next Saturday, I will be away. So you will have next Saturday off. Okay? So what I'd like to do is, since we're going to not be here that Saturday, I'd like us to do our final session that Monday. Okay? From 6 to, well, I say 9, but it's anywhere between 8:30 and 9. Okay? So that's Monday the 24th from 6 to 9. And then next Saturday you can sleep late. That's any consolation. Or you can jump up and start reading. Say, oh man, I need to read. I was going to do that. All right, keep going, Rico.
The beneficial interest under a trust may be vested or contingent. A vested interest is defined as an interest that the beneficiary has that is,
Is a benefit that a beneficiary has.
that is either already in his possession
Yes.
or will come to him in the future.
In other words, the beneficiary is certain they'll get it. Okay, that's what vested means. Okay.
If the beneficiary's interest is dependent on the occurrence of a future event, then that event must be certain to happen. Example, the death of another person.
Which is certain to happen. So, yes, you are vested, you know you're going to get it. Anytime you hear the word vested as a beneficiary, you know it's yours. Sooner or later. I don't know what has to happen for that not to happen, but normally it's yours. Certain. Okay.
Conversely, a contingent interest is defined as an interest that the beneficiary has that is dependent on an event that is not certain to occur and is not a vested one.
Okay, so if somebody tells you you're a contingent beneficiary, don't be too happy. You could be sort of happy, because contingent means you may not get it. Do you follow that?
Mm-hmm.
Vested means you will get it. Contingent means you might get it, or not. Okay.
A contingent event may be the beneficiary reaching the age of 18 or 25. In this case, the beneficiary may die before reaching the required age.
Which means you will not get it.
Therefore, there is no certainty in them attaining their interest. This interest may be contrasted to the vested interest, which is dependent on the death of another person.
Yes.
As everyone dies at some point, and the beneficiary's interest is based on a certainty and not a contingency.
Now, even in this case where it's based on a certainty, who could die first? The beneficiary. Before the person. And if you die first, you still don't. But maybe based on the arrangement, who gets it? Your children. Yes, your heirs. Absolutely. Okay? But theoretically, we presume, okay, the settler is going to die first, and so it's certain if it's based on death. If it's based on your reaching a certain age, it's contingent because you may not get to that age. Okay?
If you have no children, then that's
Depending on the arrangement, if it says, uh, well, theoretically, what will happen is this: if somebody says, "Upon my death, you will benefit," okay, but the beneficiary dies, the person who was supposed to die first doesn't die. So they'll reshare, yeah. There'll be, you don't have to say, well, it passes on, because the person who was supposed to die is still alive, you die. So your children may not necessarily benefit. The person who's going to leave it to you, if you die before them, then they will do what? Reassign. Absolutely. And to create a what? New beneficiary. Absolutely. Okay.
As a beneficiary, he has certain rights under law in relation to the trust and trustees administration.
And as we will find out, beneficiaries have a whole lot of rights. That's why when beneficiaries find out that they have money coming, vested or contingent, they start hounding trustees sometimes. Okay, professional trustees will tell you, and even some personal ones, when it's time for beneficiaries to collect, and sometimes before the time, they start checking in. They start checking everything to the penny. Are you sure this is something I'm supposed to get? Did you calculate it properly? How come you sent my payment late? Last year you sent it late. You sure this is the correct payment? How come Susie got more than I did? Is the trust? And then all things start getting weird. Because once people know they're entitled to money.
So they would know that each beneficiary.
Not necessarily. Not necessarily. Some people don't even know they're beneficiaries. And that's how the settlor wants it. Other people know they're beneficiaries because they're getting what? Distributions or payments coming to them periodically, whether it's 6 months, 1 year, every 3 years, whatever it is. So they know they're beneficiaries. There are other persons who are not entitled to distributions or payments from the trust. They may not know. Their only entitlement might be that they will get the capital out of the trust fund if the trust fund is dissolved for some reason.
So, most cases, beneficiaries won't know each other.
Not necessarily. If they're related, they're going to talk. If they're not, because remember, beneficiaries are not all related. You can name whom as a beneficiary. Anyone. Okay? If you have your best friend who was a good friend to you, you might name that person as a beneficiary and your children may never know. Okay? Of course, the trustee has a fiduciary responsibility not to tell the children there's another what? Beneficiary. Because if they do that, then they can start hounding them as to who, why. Yeah, which is not uncommon. We have something called a secret trusts, and sometimes secret trusts are established primarily for that, for outside children, the other woman, and stuff like that. No, it's not only the other woman, it's not the other man. Like chicks don't leave nothing to do. What? That's a strange situation. I don't leave anything for guys under no second. Well, with a few exceptions.
That man is going to marry somebody else and he's spending my money on him.
Oh. But women marry other people.
Some people just aren't nice to people, and so why should they leave you? And some people don't take care of people.
Yeah, that's
and
true.
a lot of instances, you have a lot of men who do certain things, and so that's probably why some women just say,
Yeah.
if they, especially if they have kids, if you didn't take care of them like the way you should, which in a lot of instances, that's
Yes.
what happens. A lot of women become like, instead of the men being the head, the women become the head.
Yeah, they force them to be.
The slack. So
Sure.
then why should they leave you if you already are not doing what you're supposed to do in the home? Why
Correct.
should they leave you money to squander or do foolishness?
No, you shouldn't. As a matter of fact, no spouse should leave anything to any spouse that is irresponsible, whether it's male or indeed.
You have some men who will be leave for their children. So
True, because their wives are, in their opinion, whatever. Yeah, absolutely. But when it comes to our children, we leave for them no matter what condition they're in. no matter how stinky they are, because they are.
Some
Yeah.
might get more
But
than
some-
others.
Yeah, yeah, some-
It depends.
Yeah, but they all still get something.
Some
Yes,
age with conditions.
absolutely.
If you know your child is
Yeah,
is
and trust me.
Waste money, then we call them spendthrifts.
Responsible.
Oh yeah, that's one of the reasons why we have trustees. Did you know that? Because if somebody has a great big legacy of tens of millions of dollars, they're not going to leave it for a particular child. No,
Responsible.
hell no. They'll leave a trust fund and they'll say, give that person enough to live on, but not a dime more. And don't leave any other responsibility for that one, because that one will squander it by all means. And then the others who are more responsible, they're different provisions by all means. That's one of the primary reasons for setting up trust as well, to deal with incapacitated children and spendthrift children. Because man, if you're persons who don't know how to stop spending, absolutely, absolutely. Okay, keep going.
Both statutory and common law require that the beneficiary has the right to information regarding the trust except information that may be prohibited by law.
So as a beneficiary, you can get information as long as the law doesn't prohibit it. One of the things that the law prohibits is beneficiaries getting information on how trustees make their decisions about how to distribute the trust funds. Okay? So the either is there's certain information beneficiaries get and there's other information they don't allow them to get. Otherwise they'll be fighting all the time, contesting things all the time, carrying stuff to court all the time. How come you made that decision in favor of my sister and I didn't get the same treatment? I'm suing. And then they tell the brother, says, what's wrong with me? I only got $10, how the hell? And then they start fighting and you're wrapped up in court all the time. Okay.
Section 83 on the Trustee Act of the Trustee Act of 1998 gives beneficiaries of the Hayman Trust the right to information under certain specified conditions and in certain specified circumstances.
And none of those will be known until the specified time when the matter gets to court and the bloody lawyers start arguing and arguing to make more money while they try to resolve your matter. Okay.
One such right is the right to information regarding the production and receipt of trust accounts.
Wow.
As and when requested by the beneficiaries.
Okay, as seen in
Green.
yeah, Pierce versus
Green.
Green. Remember, you can go and check these cases and you're required to do it to see whether you can find in the case how the particular situation relates to that case. So when you Google Pearson versus Green, you should in fact be able to see this information about disclosure to beneficiaries. Okay.
Beneficiaries have a right to inspect trust accounts and demand information and explanations on them. Under common law, beneficiaries are not entitled to demand copies of trust accounts unless they are prepared to pay for them.
How about that? You think?
Repossessing.
Yeah, do you think any beneficiaries have a problem paying for it? No, because they want to see it. But believe it or not, there are some beneficiaries who will fight you if you tell them they have to pay for it. They'll sue you not to pay, even though they're only paying what? A couple bucks. Okay? Folks are really strange in general, and people are even crazier when it comes to money issue. Make no mistake. You want to find out if somebody is really your best friend? Have a money issue. And then see what happens when all that passes. Somebody really loves you? Have a money issue. And see what happens when that, because people get really strange when it comes to money. Okay.
Under Section 83 of the Trust Act, beneficiaries are not allowed to obtain information regarding trustees' deliberations.
In terms of how they're thinking when they're making their decisions, okay? They don't want beneficiaries mixed up in that. You can see how the problems can pile up. Okay?
In relation to distributions to them. Therefore, beneficiaries cannot demand documents such as minutes of meetings
Indeed.
and correspondence between the trustees, particularly those which may specify the trustees' reasons for the exercise or non-exercise of his discretion in a discretionary trust.
And we all know that discretionary trust is a trust that allows the trustee to make decisions based on his own experience and expertise. What is the opposite of a discretionary trust? Non-discretionary, known as also a fixed trust. Okay? In a non-discretionary or fixed trust, the trustee can only follow instructions from the deed. But if it's a discretionary trust, then the trustee is allowed to make decisions on his own in accordance with the provisions. Okay, folks? All right.
One primary reason for prohibition on the right to information is the possibility of a challenge of the trustee's discretion by
Aggrieved.
beneficiaries.
Who do you think aggrieved beneficiaries are? Those who are, in their opinion, pissed off for some reason. Yeah, they're upset. And you know, when people start getting upset, in general, what happens? And specifically when it becomes related to what? Money. Yeah, money issues. Alright?
Additionally, beneficiaries have the sole and exclusive right to sue trustees in relation to a breach of trust or any other legal action regarding the administration of trust and their duties and obligations to them.
You see that? Sole and exclusive. The settlor cannot sue. The protector cannot sue, and that's it. He has provisions in the trust deed. The beneficiary is the only one with this right. Okay. Why? Because they are the what? Equity owners of the trust. They're the ones who, by law, are the beneficiaries and the ones who will benefit from that trust until the trust comes to an end, whenever that is in the unknown future. Okay?
It should be noted that Section 23 of the Trustee Act 1998 does allow trustees to insure themselves from the trust fund for legal actions brought against them by beneficiaries except for breach of trust.
So if you're a trustee, you can buy insurance, liability insurance, using the trust funds, not your own, to pay the premium to protect you against lawsuits by beneficiaries. However, if you're found to be in breach of trust, then you will have to pay out of your own pocket as a trustee, whether it's a personal trust or an institutional trust. All right, and then finally,
beneficiaries cannot dictate to trustees how they may administer or operate the trust.
do you know why that clause is in there, that sentence? Because there are many beneficiaries as we speak who are always trying to dictate to the trustee. And depending on the relationship that the beneficiary has with the trustee, they are always looking to manipulate the trustee, especially if somehow they found out that the trustee has what? Discretion. See that word discretion? That's a crazy word. Don't give any discretion to anybody unless you trust their judgment. Otherwise, well, if you haven't had that experience yet, do it carefully. And trustees are indeed on the top of that careful list. Okay.
Beneficiaries cannot dictate to trustees how they may administer or operate the trust. However, they do have the ability to terminate the trust and compel vesting in the trust under the rule in Sanders versus Fortier.
Very important case. Please, along with the other ones, you must look at Sanders versus Fortier and the other ones. But this is a case where beneficiaries have the legal right to terminate a trust under certain conditions. And once they find out from their lawyers or otherwise that they have this right, sometimes they can come together to what? Exercise that right. Especially if, in their opinion, you piss them off, or they don't like you as a trustee anymore, or they don't want to deal with a trust relationship anymore. You follow?
So what happens when they terminate that trust?
They get the assets will be distributed according to the trust deed, the trust law, or the courts. Absolutely. Okay.
As required by the rule in Sanders versus Fortier, beneficiaries may all be ascertained sui juris.
What does sui juris mean again?
Of legal age and capacity.
So if you're 17, you can't be part of that arrangement. If you're crazy, quote unquote, or deemed to be incapacitated, you cannot be a part of that arrangement. You must be of legal age, 18 or older, and you must have the capacity. You must be in your right mind. Okay.
And in agreement to terminate the trust.
So those are the conditions. You must be ascertained. What does that mean? You must have been designated as a beneficiary. You must have sui juris capacity of legal age and mental capacity to act, and you must be in agreement. So if there are 29 and one disagree, if there are 2 and 1 disagree, you follow, folks? It's just like when if 2 people are married, they want to sell a house. If one wants to sell and one doesn't, house rots. There are a lot of houses in Nassau that's rotting because the other party will not sign. I'm not signing until I dead, and then I'm gonna leave my thing to my children and I tell them to all those and so on. And so stuff just sit. You say 1 decade after. Yes, because nobody wants to, sign for whatever reason. All right, and then final paragraph, Rico.
The trust fund or property is then distributed to the beneficiaries in accordance with the
There you
provisions
go,
of the trust instrument.
Sabrina.
Even in such distribution is not in accordance with the wishes of the settler.
Do you follow? So even if the distribution is finally not what the settler originally wanted, and is stated in his letter of wishes, once they all agree and it's terminated, the trust agreement will determine who gets what. And if they can't find anything in the agreement, then they will go to the act to see who gets what on termination. If they can't find it in the act, they go to the courts, who will tell you who the hell gets what. And once the court decides, you can object all you want after that. When the judge does it, that's it. Case closed. All right, so I'll see you guys on Monday the 24th. Make sure you use. Sorry?